give thoughts as you go, but this will be your presentation. And we have microphones in the room that I can pass around as people have questions. So if you want to like get feedback, you're asking for feedback, I'll have the microphones. I can pass it to them and you can talk to them. Great.
Experience.
I'll make it big. Yeah. Okay. Yeah, that's great. We're still getting people back in the room from lunch because it's always hard to do, but we'll get them back here in a minute and then we'll get started.
Perfect.
Magical.
Indonesia, oh wow! Wow, this diverse and hey, Catherine. Yeah. Yes, yeah, it's okay. She doesn't enjoy it. Say this, but then maybe if you have people part in the program, I think it's fine. There are negative. Yeah, I have friends. We're loving it. Yeah, yes, same. I guess that can you guess? Okay, I guess. Can you guess from our? No, it's not yet now.
Doing a little bit more of an advanced session on oral advocacy. So this morning we did just the regular nuts and bolts basics of oral advocacy. And Giannis, just so you're aware, if you didn't see on the schedule, we've done breakout sessions on both claimant and respondent arguments for the procedure and the applicable law issues. And now we're doing a more high-level theory of being persuasive. Giannis's presentation will go through more about what it means to be persuasive and some of the technical theories on how that works, just to help you guys have some vocabulary and understanding on how to actually be persuasive and use your logic. And then we'll have some more practical applications towards the end and get an idea of what can be useful for us. So Giannis, go ahead and take it away.
All of you to this lecture. I'm happy that you're having me once again, even though I cannot be with you in the room this time. Last year, approximately like 11 and a half months ago, I was sitting exactly where you're sitting right now, being quite excited about the pre-moot starting in a few days for my mooties. I was a coach already last year, but still I was excited, you can believe me that. And I can really say that I enjoyed my days in Abu Dhabi, so make also the best out of yours. You have, once again, excellent coaches and experts with you. You have excellent facilities there. So I'm sure that this program can be very, very fruitful for you. And I hope you will enjoy your time. One part of that is now the oral advocacy theory and advanced skills lecture, which will go for the next approximately 1 hour. And as Robbie just said, we are currently now on the transition of talking about the Wismut problem itself on a substantive level, understanding what the issues are that we want to present. And that's a very big cornerstone for what is going to follow then. But now that's also a big part of a mood competition. Now we're talking about more general things about how to present, about how to be persuasive, about how to show maybe charisma or something. Basically answering the questions that lots of you have in the beginning, how to become an excellent speaker, how to maybe in the Vis language reach the points of 90 and plus that qualify you maybe for an honorable mention, or maybe a bit more abstract and generally speaking, how can it be the case that speeches that we read about in history from maybe 1,000 years ago were considered back then as excellent, and today they are still considered as excellent, or persons are considered as persuasive, and today they are still considered as being persuasive. And you will see that there are actually quite a lot of things that we directly can translate to the Wismut and to your pleadings for that. So now all of that sounded quite abstract, so let's loosen it up after lunch for you. And we will start with a practice game, which is quite simple. We need a volunteer for that from your rows. And I hope that it will work properly because I just had a bit of issues understanding you perfectly from the room.
All right. We got you. Hold on. We got one. Do you need more than one?
Right now I need one. That's
Okay.
good. So you can first tell me your name, and then second, your task will be to choose one of these three statements. They are already assertive. They should not reflect your beliefs. That's not the point of this exercise. But the point of this exercise is that you are trying to make just one point, one sound point, why you think that that this statement is true. And I'm going to interrupt you and try to challenge your argument as to that.
Okay. So hi, Janice. We talked before we met with you, but my name is Bahadur, and I'd like to choose third one.
Okay, feel free, go for it.
So could you please explain, should I like
So the idea is basically that you are trying to make a very short argument as to that, but you are trying to avoid me to make or to prohibit me to ask the question why, because what I'm going to do right now is going to ask why as often as possible, and I'm going to try to attack your argument by just asking you follow-up questions.
Okay.
How that plays into this presentation we will see later, but.
Okay, got it. So I need to do all by myself, explaining why this is better than this, right? Okay,
exactly. So you start your sentence with, I believe that cycling is better than horseback riding because.
Okay. So I believe that cycling is far better than horse riding because it gives your muscles to make your muscles work overall. But however, when you are doing horse riding, it means like you're not moving at all, but only the horse is acting, but you're not. So
okay, so first of all, why is it good if we have our muscle movement? Why
because
is that an advantage?
It's good for health to be active all the time and just like keep the hygiene and just be strong.
Mm-hmm.
Physical statement, improve our physical statement. So.
And why can you say that on horseback riding we are not improving our muscles? Because I guess we are also like very focused when we're sitting on a horse not to be thrown off. I think often riders also have very strong legs.
But yeah, there are some theory, but I don't believe that this is far better rather than cycling. So cycling is much more active, I'd say, activity to do to make your muscles work and get what you want to improve your health conditions and keep fit. So.
And why would you say that having good health conditions is important?
To live longer.
That's a good point, I would say. Okay, perfect. That was an excellent example already. And I guess it sort of already hit the point. We don't have to artificially overstretch it, that I want to make, and we will come back to that later. We basically learned right now two things. First of all, if someone tries to argue against each possible statement, it does not make sense to argue with that person. If I would now have asked why it makes sense to live longer, it would just have been either very philosophical or second, just pointless. So that's one learning. And a second learning is still that from an argument that seems to be valid on the first glance, probably there are lots of different layers where we can attack, where we can ask questions, and where we also challenge the speaker, the oralist, the presentator, in justifying him or herself for the statement they made and inviting them to make mistakes. We will not go through all of these examples now, but in the end, we will do such a game again, so you can already be prepared for that. Now we will go in medias res to the agenda, and we will talk first about the theory of persuasion, and then very simple afterwards about how to apply that for the Wismut. Now let's talk about theory of persuasion. We are not the first generation of people thinking about how can people be persuasive? How can arguments be persuasive, more persuasive than others? Because I think that's something that was influential throughout history and throughout times. And very early on, Aristotle, I guess you call it in English, but I'm not sure, a Greek philosopher, was coming up with this systemization, saying, okay, we have three pillars here. We have the logos, like logical arguments being fact-based. We have the ethos, and we have the pathos. And by the way, pathos and ethos should be switched here. I'm just seeing pathos is the emotions and ethos is the character trust. So I had, for example, on my last lecture when we were still in Dubai, the example of a dentist, and I will just repeat that for a second to have a feeling for that, or a commercial advertisement for toothpaste. If we would say that 8 out of 10 dentists recommend this and that toothpaste, we would call that about like being a character argument, a trust argument, an argument by authority, because it's a dentist saying that. In the Wismut, we have exactly the same kind of arguments with judgments, with scholars being an authority, which we don't have to then later necessarily sometimes reason. If the commercial would say, okay, if you have bad teeth, you will not be successfully finding a partner in your future life, that would probably be an emotional argument. And if the commercial shows you that within like 2 weeks of use, approximately 80% of the plaque will be removed, and the teeth are an average 1 degree whiter, that's probably a fact-based logical argument that shall persuade you to buy it. We will talk mainly about persuasion by logic today, because you are lawyers and you are not marketing professionals. So we will also think about how you can implement ethos and pathos into your presentations, but what we are talking about now mainly is logic. And the classical starting point for logic, that I guess is also not to underestimate here, is the so-called syllogism. So basically saying that we have a conclusion that is always a consequence out of two things, which is once a first premise and then a second premise, or a major and a minor premise. So to be very abstract, for example, every square has corners would be a very abstract general major premise. Then we would further say a circle does not have corners, so we can draw the conclusion without having any further knowledge that a circle is not a square. Also, we can say that all lawyers are human beings and that Robbie is a lawyer. So probably, not only probably, but surely Robbie is also a human being. Or talking, for example, more about Wismut problems.
There are a lot of people who are not convinced by your syllogism.
What else? A reptile?
Yeah.
Ignorance of pre-arbitral procedures always leads to inadmissibility of a claim. Claimant ignored pre-arbitral procedures, so the claim needs to be inadmissible. Sorry, that's a wrong wording in the last conclusion. But I guess you get the point. And a CREC should often go in this direction. We will see that in a second again. But you will also see that here usually you would receive questions always when, as it was just in the introductory example, there is an in-between step not explained in your syllogism, in your logic. When you base maybe a premise on one that you did not establish yet, then you will be asked questions by your arbitrator. Okay, so how to attack this? That's interesting for the Wismut because you will have to think about how to defend on one hand. And on the other hand, also it will help you to maybe find rebuttable points. So first of all, in our example right now, the last one, what does ignorance mean? Do we actually have ignorant behavior? Or is all ignorance leading to the inadmissibility? Regarding always, like what happens if a party acts abusively? Can we find any cases where this general rule would not be applicable? The same we could do to the minor promise or to the conclusion. Could say, is inadmissibility maybe the right legal consequence of such ignorance? Is it maybe a lack of jurisdiction, as some teams might have argued, or not? Or maybe we are quite right with inadmissibility. All of this sort of transferred, and that's just because it's very close to the CREC, but it does not have anything to do with law. I guess an interesting graphic that we can just talk about for a second. Here, basically, what we see is an idea about how to be logically sound, and what communication scientists there came up with is basically a CREC. What we have here is a claim and data. That's the two things. We want to make a claim. That's our job as a lawyer. And this claim, we want to reason with the data that we have. And for that, we need two things. We need a warrant, like a general principle, like a statement that we put on the claim that then validates the claim based on its relationship to the data. And we need a qualification of the claim itself so that it is not absolute. So basically, we have to think about a precise conclusion that we want to make, a qualified one, that leads to the next steps that we want to, that are favorable for our position. But we also need to have the data available that leads us there, and a like connecting tie to the claim. And once again, we could ask: is the data reliable?
Can you,
is the data actually
Giannis?
Yeah.
That last chart was kind of a little bit hard to understand, I think. Can you give an example of what that would look like and identify the different pieces for us?
Okay. Let me think on the spot. I could say, let's go back to our initial example. Cycling is better than horseback riding, yes? So let's think. We have a claim that is cycling is better than horseback riding. And we might have data right now that, I don't know, I'm not a sports scientist, that cycling actually burns more calories, is better for your overall health than being on a horse. But then you would also have to make a warrant, like a general principle, stating that being healthy is good, leading to your claim, like making your claim actually a good position. So you would first have to make a general principle, like the warrant, saying, okay, being healthy is good. We are getting more healthy by cycling than by horseback riding. That is can be seen on this and that data. And further, we can also see that a bad cyclist is still like less fit than a good horseback rider. So we have to qualify and have to say, okay, it's not always the case, but it's in the majority of events the case. Did this sort of make it clear, so that we have like the data saying, okay, we have sport data here stating this is the improvement on bicycle, this is the improvement on a horse. We want to claim that cycling is more healthy. We say that having good sport numbers makes you more healthy. That's the warrant, and the qualification is to make it more realistic and not absolute.
Yeah, that's good. Any questions?
Okay, great.
Thoughts? Okay.
Okay, great.
Yeah, hold on one second.
Thank you, Yanis, for the presentation. Can you like give example from the problem itself, so we would understand as we like? That would be awesome. Thank you.
The entire world is the Vismut.
What do you mean? You mean like from the Wismut problem, or you mean from?
Like how would you use the structure to develop or apply an argument to the Vismut as
Oh, yeah,
opposed
that's
to whether cycling is better than horseback riding?
Okay. Basically, what all of this is here right now is an understanding for you that one thing that we were doing for very long is not. Wait, I will skip there. Is not like just a rule that someone came up with, but it's actually development of years and decades and centuries of communication science and logic. And that's a CREC, which is very, very similar to the structure that we have here. So once again, if we have our CREC, we have a conclusion that's basically a claim that we want to make. Then we have data. And the data is sort of something that we have to fill with our rule and application. So there we have a like two split. So we cannot directly translate this to the Vismut, and I would also not recommend you to do so. There the CREG is just more efficient as a structure, but it actually explains us what the CREG is and why the CREG is that efficient in being used. Because it is basically a direct two-step approach in connecting the data to the claim. And our data in our case is then legal research, and it is the fact of the case. I hope that sort of answered your question.
Yep.
And we will come to the CREG then on the application part. Okay. So once again, we could answer try to dispute basically each part of that. We could dispute the qualification, like in our case, the conclusion not being specified enough, not leading to the argument that our opposing counsel wants to make. We can dispute the warrant itself, and as I said, the data. Now here, this is maybe lots of text. I hope you can read it in the room, otherwise you will have it on your slides. It's also not that important because we only have examples here. For the categories that are in the headings. So what are sort of the fallacies of logical persuasion? What should you not do? Or if you notice that your opposing counsel or some arbitrators do something, that you can like spot that out and thus defend yourself. First of all, that's sort of already connecting to ethos and pathos, what we will have in a second. Fright and sentiment. That's something that can logically often be disproven. For example, Equatoriana is a totalist state with a government that tries to infringe the rule of law by being resistant in this claim. We need to defend the rule of law. Foreign investors always bring problems and don't have any interest in contributing to local society, especially when they are incorporated in Mediterranean, such as green hydro. Don't do that. Exaggeration of consequences. By denying this claim without clear evidence, you'd not only impose risk for insolvency on our client, but also create a precedent that will be abused by corporations to delay proceedings. Non sequitur, so we can challenge the conclusion out of the data. For example, the attacker was playing shooter games, therefore shooter games need to be banned, or the tribunal is bound to rule in our favor, because an essay of Professor Brand supports our argument, even though that's a good indication. That's not a necessary consequence. And the same as to generalizations, that's very similar to fright and sentiment. What I guess is very important for the Vismut actually, because both of these examples are real life stories that I witnessed, are not to argue ad hominem, so against the opposing counsel. You are arguing in favor of a legal abstract argument, and you're not arguing against a person. So two things that happened with slightly different wording in my year of participation was once a statement by an opposing counsel. Claimant's counsel proved that she does not have any knowledge about the hydrogen industry. How can you take her argument if she does not even know how an hydrogen plant operates. In our case, it was drones, but exactly this quote. Alternatively, I will waive my rebuttal as my opposing counsel failed to bring out a proper argument in its rebuttal. This will not make your point more logical. Like, we are still remembering that we are talking about logic now all the time. And your arbitrators usually are very logical persons.
And I'll just say too, I think when you guys look over these slides later on, because there is a lot of text here, each one of these are going to invite questions from the tribunal that you don't want to have to answer. So they're common when you're doing your arguments, but if you're using some sentimentality about what you have for either party, positive or negative, it's going to invite a question. Why does it matter whether they're totalitarian? That's not a matter of the claim. If you're exaggerating the consequences, you are unpersuasive because you aren't trustworthy and you're not telling us that the actual consequences of your actions. And we're going to say, wait, why would that happen? Right? You're going to get incredulous questions from the tribunal. Non sequitur is the same. One thing does not lead to the other. And we're just going to like halt in our tracks and ask you to justify why that happens. And you're not going to be able to because of their logical fallacies. So it's worth getting a sense of what these are, so that when you start getting questions and you can't figure out why, you can think through like, oh, I didn't draw that line properly. I need to make sure I organize my argument better.
Yeah, I think that's an excellent comment, which also once again maybe puts all of this in a context. The starting game that we were making is very close connected to this syllogism slide that we have here, and it's also once again very close connected to the fallacies, because the only difference of all of these categories here to what we had previously is that we do not have a syllogism in each step. We just make statements that we try to give truth without reasoning them further. And exactly this reasoning is what triggers arbitrators then to ask questions. Okay, then let's talk for a second about ethos and pathos. But just to open it once, it's only one slide as to that, 2 slides. So pathos, the emotions. I just made like an illustrative example that we are once again understanding what we're talking about. Our client risks insolvency when this contract is not getting performed. This might not only be an emotional argument, as there might be legal consequences. So it might also be a logical part of it, of this insolvency. But first of all, for a judge or for any audience, that probably should just raise like identification with the subject, should maybe make one pity the subject. How to actually use it in your presentation in your favor. First of all, you should just be, once again, as in your legal memorandum, be very conscious about the wording you use. You will give the same speech probably more or less, or is improved day by day, now for the next 2 months. So you have enough time to think about each word that you will prepare to use. So also think about whether you use active or passive language there. Active language often makes it easier for us to identify with the subject than passive language. So for example, if something is negative for you, you might be tempted to use passive language, while when something is positive for you, you might use active language. The choice of subjects, whether you talk about individuals or about the corporation that they belong to, about the profession that they belong to, might make a huge difference in a simple argument. I guess consciousness is very important here. And storytelling. And I mean, storytelling is something that probably deserves a whole lecture by itself. And we will not have the time right now here to talk about that in depth, but that's exactly your chance, and we will see in which places of the submission you will have this chance to paint a picture, to tie all of your logical arguments that you have by yourself, all of your CRECs, all of your syllogisms together to a bit more than just logic, to a story, to something that makes someone identify with your client and that makes it even more likely to follow you. Ethos, character. Professor Bourne in his commentary clarified that. You will hear this sentence quite often. It's not bad per se, but it's also not just logical because of it. So what is it? First of all, we can, I guess, kind of like get closer to ethos by describing it as like character, as personality, as the values a person shares, as the authenticity that a person brings with itself, maybe even without trying. That's something we can often see in great politician speeches and so on, but also for lawyers. And I guess the idea behind all of that, behind the ethos, why it is a part of being persuasive, is that we are kind of trained as human beings to trust what is similar to ourselves and to be kind of first, a bit distanced to the things which are very different to ourselves. And as legal professionals, we try to be, as I said, professional. We try to uniform certain things. We try to streamline things. We have certain dress codes, actually, but also in the way we are thinking. We are expecting a certain way of structuring an argument. We are expecting maybe certain sources to be appreciated or not. So by all of this, by dressing professionally, by having a clear desk when you give your presentation, by managing the time proactively and showing confidence, by showing character and authenticity, you can just show the persons that you are professional like they are, and they will be subconsciously more tempted to take your argument. But that's something that is hard to train, probably, and often comes along with confidence. Let's just have one short excursus to storytelling, and then we will come to the practical applications. Basically, storytelling by itself always consists of like 3 at least points, which is like, first we establish a problem. Second, we set a narrative why this problem exists, and this narrative has to be in our favor. And then we explain the rationality of that step by step, often tied in singular story streams. But that's different, however, in a legal memorandum, but also in a oral speech, as there the rationality often is expression of the roadmap. So we set a narrative, we ended the problem in the introduction, and then the narrative will come from time and time again, but will actually be explained within the singular arguments that we laid out in the roadmap initially. So think about maybe this when starting with your first sentences for your introduction. What kind of narrative you want to set. Once again, maybe a qualified one, which is not absolute. And then how to transition that to your roadmap so that you have a good rationality point as well. Once again, the more complex a story is, the worse it often gets when we try to understand something. Here it's not about creating complexities like it is for novels, for authors, and so on. Here it is about being easy to be understand. So simplicity of your story matters. Maybe try to find 2 or 3 keywords, specify them, and rely on them throughout your speech. Okay, now let's come to more specific points: oral advocacy, advanced skills for the best mood. So we already came to this slide, the CREC, and I was happy about this question previously because we can now basically exactly see that rule and application, as I said previously, sort of take the task of the variant in one model here, or basically also the data and the variant itself. It's exactly what ties together the logical syllogism. Our conclusion is only because rule and application. Now, how to attack the CREC? How might your legal argument be attacked? Or how might you find rebuttable passages in your opposing counsel's argument? Once again, we have singular categories of statements. So we are trying to break down things right now into small boxes. And I guess that's helpful often. Now we are not talking about only one argument that we attack, but first of all, we talk about rules that we can attack and applications we can attack. For rules that we can attack, for example, we can start with the most general questions. Is this law even applicable? Or if we talk about the provision itself, are its preconditions established? Can we define all of these preconditions clearly? Are these definitions that you just came up with also in line with the overall idea of this body of law, maybe in our case, the CISG? are the facts of the case that you are citing as a rule comparable in the first place? Why do we rely on this and that convention if it's only applicable in the enforcement stage and not on our current stage? On which rationale is this and that scholar's opinion based? Is that actually a rationale that this tribunal can transfer here? So all of these questions are only examples of the questions that you will be asked most often by your arbitrators. And exactly those questions, as they are the first ones you can come up with, even without knowing the case file properly, by the less informed arbitrators even more often. The same as to application. The most standard question as to that is, can you show me this effect in the case file? This is not only asking you or a question whether you are aware of the case and so on in this competition, but it is also like a necessary precondition and cornerstone of your logical argument, of your CREC structure. So without this fact that you just named, your whole argument crumbles. So sometimes if we just say in like half of a sentence our application, as I heard it at least in the first submission sometimes of my team, we might take things for granted as we were thinking about them for weeks. But guiding them to that and showing them that this pillar stone of a logical argument that is needed for us is fulfilled sometimes really pays off.
I think when y'all are doing your roadmaps is where you can do this full analysis. Like you're going to be doing it in real time too when you're doing your arguments, but you'll get good at that through practice. But you have to think about when you're writing out your roadmaps, can you satisfy all of these kinds of questions to make sure your roadmap is airtight, right? The example I'm thinking about was when we were talking about the CISG section, people are really ready to say that in order to exclude the CISG, to impliedly exclude the CISG, you need to have a manifest clear intent to exclude, right? So when you start with that, all of these questions have to be satisfied. Is the law applicable in the CISG? Is there an article in the CISG that says manifest intent? No, right? So why is that the actual standard? Are the preconditions established for even doing an implied exclusion of the CISG? Do we know what those are? And if you come out too early without establishing those things, all you're going to do is get a tribunal who asks you almost exactly these questions. So when you're writing out and preparing your roadmap, make sure that you satisfy each step and you aren't skipping something, or at least know that in the middle between your two roadmap steps that you intend to satisfy the next step to go to the next one. And that's how you'll be structuring your arguments as you go.
Excellent, excellent. I think also for the conclusion, sometimes I'm witnessing that if the research is not deep enough, teams often tend to find very general rules defining what they are talking about rather than leading to the affirmative statement that they wanted to make. And then they have an application that showcases basically that we talk about this abstract category. So, for example, that we have mediation at hand or a mediation clause, but that's just not leading to the conclusion. That's just going like left or right from it. So also be aware for that, and your arbitrators will be very aware for that. Often it was the case already that people will interrupt and they will say, I see your point, but I totally don't see how it leads to an argument that is favorable for your side or anyhow relevant for this argument. So might you please proceed or take one sentence to explain me how it is relevant. So also make sure to think about the conclusion being a consequence of rule and application. Okay, now we come to the more specific points of a pleading, because you will not only give a speech, as you know, but you will also have to handle questions. And I inserted this slide directly behind how to attack the CREC because we were already talking about questions right now. So first of all, I guess there are two things that we can talk about. We can talk about how to prepare for it and then how to interact within the situation. And both of that is something that you can master. The more you prepare, the easier you will master both of these steps. So first of all, question handling is, in my opinion, really 90% preparation and 10% it's the spontaneous skills as it appears to be in the situation. You have to know the case file and the economic implication of the case just until now really by heart, and until Hong Kong definitely by heart. It cannot be the case that you are maybe on one hand like admitting that you don't know a fact, that's sure, but also it's a much more real problem or realistic problem that affects you, especially in those situations when a question just challenges you, which not really knocks you off. If you then have like broad understanding of the case file, if you know the facts, if you know also the niche facts which are in your favor or against your position, then you will just be more creative, more flexible in coming up with an answer that satisfies your arbitrators. You have to create a register of questions and answers. That's what we are doing each year so far that I'm involved in the VIS. Like from the very first pleading, most of the teams have more than 2 team members, establishing that only those who are actually speaking like are exempted from this task. Everyone else has to write down each single question asked by any arbitrator in practice rounds, in pre-moots, and in the end, even maybe in the competition. So that we have a list of those, that we can compare the answers that were given by our team member, and also maybe if questions were raised to the other side. And that we just like, yeah, once again, expand the knowledge of preparation, expand formulations also, improve formulations for the answers that we are giving. And you will see that there's a high likelihood that questions will come again and again. Maybe 70% of the questions will be questions that are asked repeatedly, and only 30-40% maybe are some that come spontaneously only because of your submission or your specific argument. So you can prepare for these.
Something we haven't talked about that I want to kind of bring up here is hypothetical questions. So you'll get arbitrators who will say, let's say that respondent actually did this, right? Let's say that the evidence was not submitted with the answer to the request for arbitration. Would we still have a problem with the admissibility of the evidence? Let's say we know that it wasn't illegally obtained. Do we still have a problem with the admissibility of this evidence, right? When you get questions like that, how do you think you answer? What happens when they ask a question that's outside the scope of what actually happens? What do y'all think we should do to answer that kind of question?
I think we can answer the questions. First, we appreciate the arbitrator for asking me. I thank you, Miss or Mrs. Presiding, for bringing up this question. I understand your view. However, I don't believe that this is relevant, and I'm conscious of my time. So if you'll allow me to move on second or something like that, try to avoid it a bit.
Okay, avoidance is a strategy. What else? Who has other ideas?
I'd have to disagree. I feel like the arbitrator would get mad if I try to avoid his question. I'd say just answer it while trying your best to stick with your original game plan. So yes, however, I'm sorry, the question was the admittance of evidence, correct? Okay, any hypothetical question could be, yes, it would be. However, considering that's not what happened, and continue moving forward.
So tell her that it doesn't matter.
I would specifically state that either here the tribunal maybe would rephrase this question. Maybe probably sometimes we understand the question wrong or we go to it through a different direction. But also if it still stick to the same question and with still a wrong concept and not addressing the thing that we're trying to address, maybe we could respectfully try to correct the tribunal by being respectful. So by addressing the tribunal, they maybe confuse the two. So let's say just I'm a claimant, I'm trying to include the exhibit C7. They could have confused me with the respondent by excluding exhibit C7. So we could respectfully correct it, then state and try to answer their question based on that.
Good.
I think I would try to refocus the attention on the actual facts of the case. I would say understand that's a hypothetical situation, but in the actual facts of the case, it was this way. And I would go on with my argument.
Good.
Yeah, just give a yes or no question, and if the question is also helpful for you to move on with your argument, you just don't stop. You answer the question, and you just keep going with the argument that is relevant.
Okay, good. So notice everyone had completely different approaches to how to deal with hypothetical arguments, right? It's hard to do because you are so focused on your argument. That's the thing that I thought was interesting about I think every one of you said, just so I can get back to my argument, right? We'll say yes or no, and then just focus back on my argument. We're going to tell them that that's not appropriate. We're just going to get back to my argument. We're going to try and correct them, then we're going to get back to my argument, right? You do need to address your argument, but you really need to address the tribunal's concerns, right? Their question may not be directly related to what that circumstance is because we all know that hypothetical is not what happened here. That's not the question that we're addressing, but that's a valid concern by the arbitrator, and they might be trying to test your rule, right? Do you only win if those circumstances exist? If this one circumstance is changed, is your argument as strong as it was before, right? So when you're dealing with hypotheticals, I think it's important to do your very best not to be dismissive, because again, we're very sensitive, prideful people, arbitrators, but you need to address the question. So it's kind of like a snippet of basically everyone's approach, but I'll finish it after you this question.
Would it work if we answer the question, but I think my approach would be trying my best to answer it in a way or word it in a way which would help my client or my argument, and then continue with my points.
No, so sort of, right? So if I say, what if respondent didn't submit it to the tribunal in its request for arbitration, or the response to the request for arbitration, right? I would say, members of the tribunal, in that hypothetical situation, we would still win for this reason. However, because this is also the case, we must make it inadmissible, right? You understand what I'm saying? You address it directly. You must answer that question. But the way you get back to your argument is to do that sort of however turn. You address it directly. Yes, we would win in that hypothetical situation. We, of course, do not have that situation here. However, because we don't have that situation here, our argument is even stronger, and we can continue on in that case, right? You don't want to dismiss it because it'll upset them and it'll make it feel like you don't care about their super clever, interesting idea that they had, because arbitrators are very proud of their hypotheticals. They thought real creatively to come up with that. So you want to address that thing, but there might be some genuine concerns. The other thing is when somebody seemed to suggest that the question might itself be wrong, like you were saying, you might have accidentally misstated something. Sometimes that's the case, but also sometimes they're chasing an idea in their heads, and you don't want that weird idea to linger, right? Because suddenly you're going to get to the award and they're going to be focused on that weird idea that was never properly addressed. So even if it's a weird chase runaway thing that makes no sense, it's totally worth engaging with, but you never accept the premise. So when they say, in this different situation, you don't just say, no, we would definitely still win, because they're suggesting that it might be true. So you need to be able to say, in that hypothetical situation, which we don't have here, no, we would lose. And I think it's actually great if you have the opportunity to identify exactly where your argument loses. And then when the tribunal says, if this condition isn't true, do you still win? And you can say, members of the tribunal, no. However, importantly, that is not what happened here. And because of that different condition, we definitely do win. You see what I'm saying? They'll trust you in that circumstance. Giannis, do you have anything on hypotheticals?
No, I don't think I have anything to add. Thank you so much for this.
Back to you.
I just was all the time going through my head through all of the hypothetical questions I received and whether I was answering them right. And I noticed that I did also some mistakes then. Okay. Then just to finish on the question, because I guess that was already collecting lots of the ideas on this slide, I would give a very concrete advice of creating one bundle, like a folder. Maybe some of you already have it, and that should contain your case file. This should contain your main legal sources. This should contain the sources that you might expect the opposing party to cite, and it should be registered in a structured manner, so that you have only one document that comes back to the point of ethos that we were talking about before, to give a professional impression. And also, once again, also to have just like the facts available if they need them. To interact, I guess lots of knowledge on your side was already proven by the way you were answering Robbie's question. First of all, you have to show them that you appreciate the question and that you understand it precisely. So sometimes you want to note it down if it's more complex, or your opposing counsel usually has to note it down for you because you don't know initially whether it's a complex question or a simple question when they just start to talk. Appreciating the question is often maybe a bit artificial. We don't want to we don't necessarily want to be thankful for each of the questions, and often a question also does not raise a concern, so always saying thank you for your concern is just imprecise. However, doing that from time to time is for sure valid and also for sure polite. However, appreciation can also be shown more subtle. Appreciation can also be shown by a short pause and by a very precise answer that goes directly on the question, because it shows that you were actively thinking about the answer. It can maybe be shown by a small smile that indicates, okay, I know that this is a point that we have to discuss, and now I'm happy to provide you with the answer for that. So it can be sometimes a bit more subtle and maybe a bit more smooth than always saying thank you for the question. And then, as you also said, you were right now using the phrase of coming back to your argument. I was writing right now here initial argument rather, because as Robbie said, it's not only like it is your time, it is your argument right now, and you have something prepared for a good reason, but you have to connect it to your thoughts and also to the way the debate evolves in these 15 minutes. So no, don't just like strike back, so let me come back to my argument, but rather show why this is connected to your argument by itself already. And also always answer directly. Don't say that this is a part anyway of your third argument, but you answer directly and show flexibility within your submission. Okay, this is just very short because we can simplify this idea with basically looking at the graphic on the downside. The idea of cohesion is just that we want to be once again precise. We want to make it easy for the listener. So when you have your singular C-Rex, when you have your roadmap, when you have your conclusion, then also show that like by having once like wording, like having phrases that connects that. That's the most obvious thing to do. That's what you did for the last months in the memorandum, when you transition from a rule to an application by saying in the present dispute X, Y, Z. Or if you came to the conclusion by indicating to conclude or in summary, then it does not have to be a good conclusion, but at least we know that it is one. And if it's a good one, it's very easy to understand. Now in the oral stage, you also have the chance to do so by intonations, by pauses on appropriate stages. And those can be sometimes very, very effective. If you take a look in the last year's winners of the moot, also 2 years ago, I often remember that those speakers were often having their most effective moments in a pause after they made a very good argument, and then with a very effective first sentence for the second argument, leading to this conclusion. So be aware of pauses also being part of the music, as we would say in Germany, I guess. Don't know whether that's international. You will start with your strongest argument. This has a very simple reason. It's the time management, because it might be the case that that you will receive lots of questions to this argument. And if you were preparing to have a very good argument as like third or second point, you might not even come there anymore. So tell the tribunal directly what your strongest point is, or you will not have that much of attention as you have in the beginning. And that's basically your chance to shape them, to show you whether you probably have something from the very first second that convinces them, or whether they are already a bit doubtful because you start with a weaker argument. So put them on your side as early as possible. Let's talk about a few of style points.
5-minute warning, Giannis, just heads up.
Yes.
Just saying you have about 5 minutes left, just as a heads up.
Sorry, I was. Sometimes it's hard for me to understand you, but thank you. Now I got it. Okay, I guess we can make it easily through it. So eye contact all the time. It shows also that you're flexible. A necessity for that is that you will not have a script. So clean desk policy is what I'm writing here. Right now, it's obvious that you have a script or sometimes even your full submission. That's okay. And I would also recommend you to write full submissions out of skeletons until the very last week of drafting. But I would also suggest you to already start in 2 weeks to not take these notes to your pleadings and rounds, because it will in any case be very hard to make this transition to plead without notes. But also in any event, it will pay off tremendously. And after 2 weeks approximately of regularly pleading without notes, I'm quite sure that you will have the flexibility that you need to feel also confident without them. It makes a huge difference for the arbitrators whether you come to your table with hundreds of pages, even if they are organized, that you rely upon, or whether they see that you have it all in your head. Just shows that you were putting in lots of effort for the last weeks. I already indicated that pauses are not problematic per se, also not when answering questions. It just shows that you are thinking, and thinking is something that lawyers should do. So that's not bad. Speak slowly and clearly. I would really say that this is like a pattern each year. Especially those which are good oralists in the end often start too fast, and often you also don't have a feeling for how fast you're actually speaking. The difference here is just that we have very complex topics to talk about. It's not that you are explaining your yesterday or tomorrow's plans to a friend, but we're talking about very complex legal arguments here. So it just takes longer to understand it. You would be slower in reading it if it's a textbook than reading a novel. So also give your arbitrator more time to understand it than to understand your story about yesterday's plans. Okay, I guess the rest we already sort of have. I guess one point that I want to still outline is guide to the key exhibits and explain them before getting to the information that you rely upon. So, for example, practical situation, you want to guide to, I don't know, let's say exhibit C1, and let's assume it's on page 10, and let's assume it's a witness statement, like it's a different case than ours right now. Then your arbitrators will need time essentially to come to that page, to go to page 10. So don't wait until they are there to explain them what they see there, but use this time to say, on page 10 of the case file, you can see the witness exhibit of person XYZ who has this and that role and task and responsibility. And please indicate when you're with me, or you don't ask this question, you just are actively observing. And then when they are with you, you can show them, okay, now when we're here in line 4, 5, 6, we can find the relevant passage, I quote. And then you ensure that they are once with you. Second, they know what you are talking about. And third, there was no awkward silence while finding the page. Okay, in light of time, I will just summarize the key ideas of these slides, and you will have them in the retrospective to go through them. Be very aware of the audience that you have. Also, when it is your arbitrators, practically speaking, Google the names of the arbitrators that will be announced in the foregoing of the events for Hong Kong and for Vienna as well. And maybe you will find some LinkedIn publications. Maybe you can find whether they have a civil or a common law background. And like this, you will already have a bit more certainty of what kind of questions to expect, of whether it's favorable to include one more case instead of that scholar that you so far were citing in your submission, because maybe a common lawyer might be more convinced by such an argument or such a rule. Also, I guess that's something we can do in a few seconds, but it is not to be underestimated. Your scoring will not only happen while you are pleading. Your scoring is happening throughout all of this 1.5 hours that you're sitting with the arbitrators in the room. So it starts with introducing yourself and exchanging business cards, and it stops with receiving your feedback and saying goodbye and thank you. Because all of this time is basically the only time frame for the arbitrator to get an impression of you as a person. So for example, if you value his feedback, you might think, okay, he was valuing also previous feedback. So it's more likely that his submission right now was just a bit worse than usually it is, but I can see that he is a smart person and that this argument by itself is solid and that he's actively listening to feedback. So I will give rather these and that points than another 3 of points. In the Vismut, we don't have very specified like scoring criteria. So all of these points are even more relevant than in other moods, I would suggest. Keep your posture professionally, show interest also while you're not speaking. Write down the questions for your co-counsel and assist with answers and time management. Okay, this is already the last slide. I see that my time elapsed. So I would suggest you to maybe I would probably suggest you to do one thing in the retrospective regarding this lecture, it is going to this slide and thinking what kind of ways to persuade someone also on a theoretical level we have on each of these phases, because this might sort of help you to outline a speech if you don't know how to systematically improve it. Okay, then I'm sure that you have lots of interesting courses awaiting. So I would suggest that we skip the initial game, but Robbie, maybe you can clarify whether we have some time.
We want to try and play this game that we did the first time.
Exactly.
A volunteer to do this, to ask the why questions. I saw someone move their hand. You almost got called for that. Who wants to do it? There we go.
Great. And I would be interested in hearing the third argument now, because it's like turned around. Now horseback riding is better than cycling.
Okay, so sorry, were you saying something?
No, I was just not understanding Robbie clearly whether he was assigning 2 persons in the room, one asking why questions and one giving the argument, or only one person giving the argument.
I guess you will have to ask the why questions.
Okay, perfect. Yeah.
All right. So my name is Asya, and I am a member of the Al Faisal team in Saudi. Do I read through them or do I just?
You can start. Okay. You can start your sentence with basically saying, "I believe that horseback riding."
Okay, I believe that horseback riding is better than cycling. First, I would say that it is better than cycling because horseback riding gives you more confidence. It helps increase your confidence because I believe that riding a horse is relatively more dangerous than cycling. So this sense of danger that you have, because a horse at the end is a living creature and it has a mind of its own. If it is not trained properly and it sees a leaf blowing by on the ground and it gets spooked, what says the outcome? The most likely situation is you ending up lying on your back on the ground in pain. So, or breaking some bones, like that's like the worst case scenario. Whereas cycling, unless you're riding off a cliff, it's relatively safer. So
let me ask you. Is your argument so that confidence is more important than safety?
Well, yes, I would say if it, the thing is, I just realized because my mind was focused on the first question.
Okay.
No, because my mind was focused on thinking that cycling is better.
Okay.
That I kind of switched it up. I just realized that now. So
then let's just stick to your position. I will try it the other way around. But isn't it much better if persons make mistakes and sometimes suffer pain so that they can learn from it and actually establish not being afraid all the time? Is it actually better to have a safe task than an exciting one? Aren't we always doing exciting things?
Yeah, true. Are we still in the same argument?
I was trying to switch side right now.
Oh, that was good. I thought you did great. Yeah, that was great. Okay. Now you can see why we mess that up all the time too. I think if those of you who are in the applicable law section when I was basically arguing for respondent the entire time, I think now you understand why. Well, thank you, Giannis, for that. I really appreciate that. Next up is the mediation session, which starts at 2:30, correct? I have that right? It starts at 2:30. The mediation session is going to be very, very exciting. So we want to make sure you have time to get some coffee and wake up after your sleepy post-lunch. So kind of stretch out, talk around and meet people. We have the wonderful Azil Zimo will be moderating and doing the mediation for us, as well as Michael Patrick Joyce in the back will be participating with us as well. So shake it off, get yourself woken back up again, because we're going to be a very interactive session and it's going to be a lot of fun. So we'll be here at 2:30, very sharp.
Goodbye. Enjoy the courses.